The views and opinions expressed on this website and in these videos are solely those of the original authors and are not legal advice. These views and opinions do not necessarily represent those of Sela or any other contributors to this website. No attorney-client relationship is formed by viewing the video.
Hi, my name is Lee Kennedy, and I am a worker rights attorney. I'm excited to talk to you about worker rights under the National Labor Relations Act. So, have you ever wondered if you can be fired for speaking up about conditions in your workplace? For example, is it legal for your boss to fire you or otherwise penalize you and your coworkers if you all complain about the broken air conditioning in the warehouse? Or if you talk amongst each other about a manager's bullying behavior? Or if you circulate a petition asking for better working hours? The short answer is no. These kinds of actions are protected by Section 7 of the National Labor Relations Act, or the NLRA, which says employees shall have the right to engage in other concerted activities for the purpose of mutual aid or protection. Now, there's a lot of legal jargon in there, so let's see how this law actually plays out in the workplace.
Ling Chen, are you okay? I heard Mr. Hyde yelling at you today.
Oh my goodness, Fatima, it was awful. He told me I was late getting my work done. He was in a rage. He was pounding his fist on the table. He knocked down a chair. He kicked the wall and he even made a hole in the wall. I was so scared.
I know what you mean. Last week, Mr. Hyde screamed at me and told me I was not getting my work done. He was flinging his papers in my face and hit me with his papers. When I told him I needed to use the restroom, he blocked my way and would not let me pass. He kept questioning me and blocking my way so I could not go to the bathroom. He would not stop blocking my way until he finally got a phone call and left.
Yikes, do you think HR could help us with this?
I'm not sure, but I am willing to file a complaint. It is so hard to get up every day to go to work when I know I'm going to get yelled at and treated poorly. I have also seen him yell and act inappropriately toward other employees.
I feel sick to my stomach. I'm afraid he's going to lose his temper or do something worse. I'll file a complaint with you.
Dear HR representative, we are writing to report that our supervisor, Mr. Hyde, has been yelling at us and acting in a violent manner in the workplace, causing us to fear for our safety. For example, he has pounded his fist on the table, knocked down a chair, and kicked a hole in the wall while yelling at Ling Chen. He has also hit Fatima with papers and blocked Fatima from going to the bathroom. We request that HR conduct a full investigation regarding Mr. Hyde's hostile and dangerous conduct. Sincerely, Ling Chen Wang and Fatima Garza.
Ling Chen, I'm so upset. I just got demoted from my position.
I'm so dead. I got fired today. How am I going to pay my rent?
You just saw two employees, Ling Chen and Fatima, engaged in concerted activity. The NLRB's website says that concerted activity occurs when two or more employees take action for their mutual aid or protection regarding the terms and conditions of employment. In the skit, Ling Chen and Fatima were trying to improve the workplace not just for themselves, but for everyone who had to deal with their boss's awful behavior. Therefore, their actions were protected under Section 7, and the employer broke the law by firing and demoting them in retaliation. But let's consider a slightly different scenario. What if Ling Chen had gone by themselves to HR and just complained about how the boss was treating them? That wouldn't necessarily constitute concerted activity for mutual aid or protection. In order for something to be concerted activity, the purpose of the action must be to improve the workplace conditions more broadly, not just for an individual employee. So when you're engaged in concerted activity, it's good practice to bring a buddy to make it clear that the purpose is mutual aid and protection. In the alternative, an employee could speak to an employer on behalf of other coworkers, but it needs to be very clear that the employee is speaking on behalf of others. Otherwise, an employer could argue that it didn't really qualify as concerted action. Back to the scene we just watched. We now know that what Ling Chen and Fatima were doing was protected by the NLRA, but you're probably wondering, so what? What can they do about it now? Luckily, the NLRA offers some remedies, such as requiring an employer to reinstate a fired employee and give them back pay. Both Lingchen and Fatima can file what's called unfair labor practice charges against the employer. There are forms available on the NLRB's website, which you can complete and submit by yourself or with an attorney's representation. There are, of course, a few things to keep in mind about the right to concerted activity under Section 7. Not everyone is covered by the NLRA. For example, it doesn't apply to some government employees, agricultural workers, or independent contractors. There's also a time limit on filing complaints. Generally, an employee must file the claim with the NLRB within 6 months of the violation. If you have questions about the right to concerted action, check out the NLRB's website, which offers guidance in both English and Spanish. If you want to speak with an employment attorney, check out the California Employment Lawyers Association. On our website, there's a Find an Attorney function that you can use to find someone to help you. I hope you found today's presentation helpful and learned something about the right to concerted action under the NLRA. Thank you.